First, I'd like to say peace to the gods. To True Tuesday with your host, Akeem L.
He knows more than you can imagine.
Well, the truth is, you got to get yourself together. The truth is, you got to get your mind right. The truth is, you got to get your paperwork in order. The truth is, I'm listening, but are they listening?
Hindsight Radio.
What you talking about? Okay, I'm listening. What about Tuesday? But are they listening? Yo, Akeem, pick me up. Yo, turn that on, son.
Welcome to Blog Talk Radio. Keep calm and you'll be able to listen to the show.
Yo, Akeem, pick
That's
me
loud.
up. Yo, turn that on.
Hindsight Radio.
The truth is Tuesday.
With your host, Akeem L. The truth.
Peace to the gods. You're listening to Hindsight Radio. Radio. I represent it. The information station changes the nation.
But let's look at the
This is
second
Hindsight Radio. I represent it. The information
to
station
the
changing the nation.
motion for summary judgment. That's part of your materials. And that's identified as defendant and counterclaimant, John Doe Citizens, response to plaintiff and defendant on counterclaims motion for summary judgment. Okay, what's our premise we're going to proceed under? Plaintiff and defendant on counterclaimants motion for summary judgment is a substantive and procedural nullity. Pretty heavyweight words for somebody representing themselves going into court. Brief and support. Plaintiff and counterclaimant has placed no facts on record. No fact appears on record, whether by deposition, admission, answer to interrogatory, or by affidavit to suggest or to support the averments of plaintiff and defendant on counterclaimant's pleadings. Documents proffered by Dewey Cheatham, it's not the attorney's real name, are unverified, out of date, irrelevant, and inadmissible. The record shows that the defendant and counterclaimant, John Doe Citizen, has testified and testifies again infra, establishing that material facts to which there is substantial controversy are at issue in this case. What's accomplished in this first paragraph? First of all, when you're in a pleading form, you want to know what it takes to win with that form. And when you want to win against a motion for summary judgment, you've got to state that there is a controversy. If there's a controversy, there can't be a summary judgment. And you're stating that there is a controversy. And so the court cannot decide this against you. And you're also saying that the only person that said anything in this tea party is an attorney. And I don't care how high the stack of paperwork gets from an attorney, it never rises to a level of fact. If you look at the clear letter of the law as determined by the Supreme Courts, the judge is not even supposed to look at it. It's not supposed to be noticed by the court. Just like Sanders Sauls down there in Florida with those stacks of 20,000.
Gotta unmute my mic. Peace, everybody. Thanks for tuning in to another episode of the Truth Tuesday show with your host, Akeem L, here on Hindsight Radio, the information station changing the nation. I hope everybody's doing well this evening. As for me, I am doing excellent. I want to send a shout out to everybody in the chat. Thanks for tuning in. Slough Show, Curtis Williams, Karen Israel, Yalik L, Chief Lemuel, 75816, whoever that is, Ronnie Davis, and all those who are just listening and not in the chat. Thanks for tuning in. I hope y'all listened to that summary judgment video. It's talking about if there's no real facts before the court, the judge can't even look at it. He can't even pay attention to it if only an attorney is speaking. He can't. But they do it all the time. So it's your job to object to it, bring it up, make a point of it, you know? Uh, what's what is this guy? Uh, y'all dressing some haters or whatever. um, so what do I want to talk about? I got a lot to talk about. Personal, and I want to talk about this personal jurisdiction situation from last week. But what I mainly want to talk about this week is judicial notice and how powerful it is, especially when these people like to ignore what you're doing, what you're putting on the record. They like to act like you didn't do it. But first and foremost, I got to give my spiritual spill, spiritual upliftment, enlightenment. All too often, people are complaining about how things are turning out, how things are looking, why things can't go their way. But they always seem to look to things, people, places outside of them. You know, for an example, people with no money blame the system trying to keep me down. It's the job. They don't want to give me a raise. Well, these things, these people are not trying to put you down, bring you down. You know, people do things, they try to get in your way, but really the only person that can keep you down is you. Why? Because you believe in what they're doing. You're paying attention to it. You're addressing it. You believe that they can stop you. You believe that the system is too hard. If you believe you have the power to overcome anything that comes in your way, it will happen. It's all about your belief system. That's why I played that clip about imagination. That was a clip from, I think it was, let me see here. Where is my mouse? All right, I'm working off a few screens here. I think it was Norman Vincent Peale, if I'm getting his name right. I just got imagination is everything. Imagination is everything. If you imagine bad, you get bad. If you imagine good, you get good. And if it's your belief system that's stopping you from being successful. Just imagine when you were young and you believed in something and it came true and you didn't let anything stop you. Or recently, we all have belief system. We all have imaginations. Unfortunately, most of us use our imagination in a way that does not serve us. Like, for instance, you might be in a relationship and you look forward to moving on to the next phase of the relationship, and all you're thinking about is the possibility of what can go wrong in that relationship instead of looking at what can go right. Maybe there has been some instances where some things came up that, caused you to give you some pause. That person may have acted or did something that, hey, is this the right move? Even in a situation like that, you got to look at yourself, because you have to ask yourself, what am I doing that can bring that out of a person, that a person is displaying that? That's the first question. Then the second question would be, okay, maybe this is just that person. And then you have to make a decision whether you're going to deal with it or not. You're never, ever going to change anybody's behavior. You can only change your behavior by you changing your behavior, and you're looking at everything with the outlook of positive outcomes. Only a few things can happen. That person that seemed to be negative may transform. But if they're not willing to transform their negativity, they will part ways. Either you could tell them to part ways or they will part ways. But most of the time they go off on their own, because if they see that they cannot, if they're a negative person and they're just doing this to disrupt you and cause problems for you, and they see that it's not affecting you, they're going to move on eventually. That's why I very rarely address negativity. Very rarely. When it's, especially in chats and when I'm doing my business, I never address it, especially when people are just blatantly trying to come at me. I said, I don't follow it up, because what happened? It dies right where it is. It never gets into my psychological, it never gets into my mind to mess with me. You see? Because the minute I address it, now it's in there, then I'm talking. And once you get on the roll of talking about negative stuff, it goes from one story to the next. It never stops. You see? That's why you must always remain diligent, vigilant, and aggressive when it comes to being positive, keeping your mind free of negativity. So stay positive. A lot of things is happening here at Hindsight. I working on a couple of projects, and I got one completed. Well, I got actually a couple of things completed that I'm going to be implementing in the into the premium membership. Some asset protection mechanisms. A lot of information coming across my desk. People say they have this and they have that that can change your lives, especially, that still discharge and all that stuff still coming at me. Yeah, this can be done. But then when you push it, they always say, oh, yeah, I'm waiting on this information or somebody else is doing it. That's how it goes. But big things is happening in membership. I am going to put everything on remote control, where the membership is going to change the look, where I'm taking all of the old videos, I'm going to put it up on a platform where people could just go to all of the videos when they're ready. They don't, right there on their computer, right off the web. So that is being worked on, revamping all of that, a whole new look. So look forward to that. Those that are in the membership. If you're not in the membership, I suggest you do get in the membership, because a lot of good things is coming. Real good things. So Mexa Moore said he dropped $50 for the show and we'll get it back 10 times. See, that's how you do it right there. That's how you do it. You give. Matter of fact, I haven't put my Cash App up there. You give and you will receive 10 times. See, he put a command on that. He put it, I'm going to get it back 10 times. Every time I put a command on my money, I get it back 10 times. Whenever I give, I get it back. Some people are just afraid to give because they feel like they're going to lose. You can never lose with giving. It's impossible to lose when you're giving. Long as you're giving with the honest heart, not looking for someone to pat you on the back. You're really giving to help. And yes, it's okay to expect that to come back to you tenfold. That's okay. But always give with the thought process, with the mindset of you're helping someone. And in you're helping someone, you will be helped. What you give is what you get. You give anger, you get anger. You think anger, you will receive anger. You think on bad things, you think bad things about whoever you're with or the things, you will see that all the time. People are moving and doing things unconsciously. So if I want to find something negative, I can always find it. Negativity there is an abundance of it going around. That's that whole broad and spacious road. The negative road is the broad and spacious road. The positive road, the enlightened road, is the narrow, cramped road, because to stay in that thought process it can be challenging, because there's always something coming at you, negative mindsets, situations coming at you that you have to dodge and jump over. Mentally, just keeping your mind in that space, because it's so easy to get off the path. That's what the Bible is talking about. The broad and spacious is easy to find, and many will find it. But that road to everlasting life is cramped and narrow. It's just a thought. It's not an actual road. It's a spiritual road. It's a mental road, a metaphysical road. It's everything that the Bible is talking about is how your mind works. It's all here. Nowhere else. Because everything starts with the mind. Everything. And if you want to be bold, you have to say God is thought. And you have thoughts. So therefore, you are God. You are Lord over all things in your life. You see? Someone put Proverbs 12:24. The hand of the diligent will rule, slothful will be put to forced labor. That's true. I don't know about forced labor anymore. It's voluntary labor now. People just want to go work for other people. You see? So keep in mind to keep a check on your mind. Make sure it's not drifting off into hell. And keep your thoughts always in heaven. That's where heaven and hell is. It's in the space of your thoughts. Someone put Matthew 7:13 and 14 speaks of the narrow and wide gates. Yeah, let's I'm glad you put that up. I like to read it. He said Matthew 7:13. And it says, enter through the narrow gate, for wide is the gate and broad is the road that leads to destruction, and many enter through it. So the narrow gate is that narrow space of positivity, because any movement to the right or the left, you're off it. You onto the other road. For wide is the gate and broad is the road that leads to destruction, and many enter through it. Yes, many enter through it through the thoughts of their mind. But small is the gate and narrow the road that leads to life, and only a few find it. So what is it saying? Life is being positive, staying diligent to your purpose. That's another thing. That's hard road to stay on. To your purpose, the purpose that you're here to do, to positively affect people in a positive manner, help people. That's another road. My Cash App is going across the screen. $sign Akeem L. Thank you for the donations. I can use it. I've been investing in a lot of stuff to help build the show. Thank you. So yes, stay on that narrow road. Go through the narrow gate of uplifting thoughts about yourself, number one, and uplifting thoughts about other people, number two. Because you cannot think good about other people unless you think good about you. You come first. You are the God. What's that? Do not put any other gods before me. Don't put anyone before you. You have to work on self. You have to upbuild yourself. You have to think positive about yourself. You have to see yourself as a divine manifestation of God. God works through you and works in you, and God is in you. 7:40 at this time. So let's go into judicial notice. Let's do that. Let's go into that. Okay, let me look at the chat real quick. Olivia Marlin, American national, but not a citizen of the United States, and I am not civilly dead in the court, lack jurisdiction over the name. Olivia Marlin. Put lack personal jurisdiction. Lack personal jurisdiction. And you know what? Let's go into that first. Let's do that first, because I'm glad you put that there. Let me put it up there. I'm glad you put that there. I'm glad you put that so everybody can see what that says. This is how they wrote it. And that's pretty much how I write. I don't put civilly dead. I use the Latin thing, ins legis, because what is it? It's a fiction. It's a straw man. The correct usage for straw man is ins legis, ENS, L, I put it in the chat, LEGIS. I put that in there. I put that right there. Let's share this screen. Take that off the screen. So let's share a screen here. All right. Chrome tab. All right. So to read what Olivia Vera Marlin said, American national, but not a citizen of the United States, and I am not Oliviera Marlin, civilly dead in the court, lack of jurisdiction over the name, and up and lower. That's basically what they're saying. So it's a good point. So waiving personal jurisdiction. This was a source of contention last week on the show. So let's look at overview. Personal jurisdiction refers to the power that a court has to make a decision regarding the party being sued in a case. Oh, let me say my spill. This is all spiritual advice coming from the ministry of infinite abundance. This is not legal advice. If you want legal advice, there's plenty of sources. Lawyers you can look up if you want their advice. They will love to take your money and do whatever. So I just have to say that. This is a ministry. So it said, before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the form in which the court sits. International Shoe versus Washington. So if the plaintiff sues a defendant, that defendant can object to the suit by arguing that the court does not have personal jurisdiction over the defendant. Right? Waiving personal jurisdiction. Personal jurisdiction can generally be waived. Contrast this with subject matter jurisdictions. You can never waive it. So that's the point. You can never waive subject matter jurisdiction, but you can waive personal jurisdiction simply by not addressing it in Rule 12 when by way of motion to dismiss, or by answering the complaint. That's why I tell you guys never to answer the complaint. But you still can raise personal jurisdiction anytime during the proceeding if certain elements exist. Here it is, right? Which cannot be waived. So if the party being sued appears in a court without objecting to the court's lack of personal jurisdiction over it, then the court will assume that the defendant is waiving any challenge to personal jurisdiction. So they can assume if you appear voluntarily without bringing that up first. So I always tell you how to bring it up. Now, to address this statement that Marlin put on there, so they're saying lack of personal jurisdiction over a certain styling of the name in its proper English form, in English grammar form, whatever you want to put it, right? So they're saying, okay, you may have personal jurisdiction over that all caps, but you don't have jurisdiction over this, and you haven't brought that party into the courtroom. I'm only here to set the record straight, saying, hey, I'm not this. This is who I am, and here it is in my pleading or my motion. I don't like that word pleading. Okay. Obtaining personal jurisdiction. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state which the court sits, and the defendant needs to voluntarily appear in court. Did y'all hear that? So if you don't voluntarily appear in court, they never have personal jurisdiction. So let me give you an example. This is why I said what I said last week. Say you got a third, well, let's use child support because they are notorious for mailing out letters to people saying, oh, you need to come here for this negotiation hearing on child support and bring all of these documents with you while you're at it. Like, for instance, they want you to bring pay stubs and all these other things. They're assuming they have jurisdiction to have you come there, right? Now, if you show up to court with all that stuff, you just gave up the personal jurisdiction. So you can't claim that, right? Now, but what if you don't show up to court? I just showed you, and the defendant needs to voluntarily appear in court. So they mail you something, and you never got the request for you to come to court because a lot of the child support enforcements or proceedings are just mailed by regular mail. But the clerk of court, the rules of the court state that a third party must serve it, mainly the sheriff or any other party that the court deems competent to do so or have given the authority to serve you. And they must put on the record that you were served. Do you realize that most, I would say 85 to 90%, all of the ones that I've seen never have that, meet that standard. Never. So, brothers, if you're listening and they got you on child support, you never showed up to court, here's your defense. Here's your out. So now you can say personal jurisdiction and subject matter jurisdiction. You see? So even if you're in a case and you never was properly served, you can still raise that objection because they have specific rules on how you are to be served. But it's always good to raise it in the beginning. Always good. But some people don't have that option. For instance, you're in a third party debt case and these guys supposedly served you. They go to court and stand there and say, well, I served them. We win by default. No, they don't. If you never were served. Because you never voluntarily appeared in court. Lack of personal jurisdiction. And if you have to show that, if they don't have her on the record that you were served properly, then you were not served. And the court must rule in your favor. And as an extra bonus, a court cannot just take and not address the jurisdiction. Let me see if this is the one. Let's see. I got a case up here that this happened. Let me see. Let me go all the way down to the bottom to see the ruling. I'll show you this image. Yeah, this is it. All right, let's share this. Share screen. I promise I'm going to get to. This is an actual case. You can look this up. 16 pages long. You can print it out. I'd save it. And I'll just go down and read the ruling without having to read all of that. The circuit courts do not have discretion to assume personal jurisdiction and decide merits issues when a defendant asserts lack of personal jurisdiction and the record on appeal is complete, because the Second Circuit in this case and circuit courts in other cases have endorsed the inappropriate doctrine of hypothetical personal jurisdiction. So Tiori, I don't know how to pronounce that, is warranted. So basically what this is saying, personal jurisdiction was brought up and they just kept moving. You see? So I'd read this whole case to see what happened. Let's read the first paragraph. The U.S. Solicitor General takes the extraordinary position that the second court had discretion to resolve merits issues on appeal before satisfying itself that it had personal jurisdiction over petitioner Banca, UBAE, SBA, an Italian bank with no U.S. contacts generally and no U.S. contacts specific to respondents' claims. Like the Second Circuit, the SG endorses the practice among several of the circuit courts that ignores fully briefed and argued challenges to personal jurisdiction and instead proceeds to the merits by exercising hypothetical personal jurisdiction. This is a violation of due process and inconsistent with jurisdictional principles that empower federal courts to decide cases. More than a decade ago, this court banned the practice of hypothetical jurisdiction in the context of subject matter jurisdiction. This court should now grant petition for certiorari and declare that the practice of assuming personal jurisdiction to reach the merits is likewise prohibited. So you can put that in your paperwork right there. Hypothetical jurisdiction. When you go to court and you're claiming you guys lack personal jurisdiction, subject matter jurisdiction, they keep moving and they try to rule against you. Now you're just a notice of appeal. The court assumed exercise hypothetical personal jurisdiction. They never gave clear, indefinite statements on the record that they had jurisdiction. They can't just take it. They got to explain it. You see? They got to explain it. And number two, this is what they did. The Solicitor General acknowledged that the Second Circuit overlooked UBAE's personal jurisdiction defense and revived previously dismissed claims against the bank. See brief for the United States as amicus curiae. The SG's position is that the Second Circuit's decision to ignore UBAE's personal jurisdiction defense and reach the merits was an appropriate exercise of the court's discretion. So they just Number three, the doctrine of hypothetical personal jurisdiction applied by the Second Circuit endorsed by the SG is inconsistent with the circuit court's decision in Steel Company versus Citizens for a Better Environment, 523 U.S. 839301. These are all cases you guys should look up, which ban the practice in the context of subject matter jurisdiction. Hypothetical jurisdiction carries courts beyond the bounds of authorized judicial action and produces nothing more than hypothetical judgments, what comes to the same thing as an advisory opinion. Okay, hypothetical judgment. These are key words that y'all can use. Disapproved by the court from the beginning. And you have cases to support your motions. This rule must, of course, apply to federal appellate courts. Every federal appellate court, this court has said, has a special obligation to satisfy itself not only of its own jurisdiction, but also that of the lower courts in a cause under review. And jurisdiction must include both subject matter and personal. That's why they go together. You hear it. A federal court generally may not rule on the merits of a case without first determining that it has jurisdiction over the category of claim in suit, subject matter jurisdiction, and the parties' personal jurisdiction. Personal jurisdiction is an essential element. Without which the court is powerless to proceed to an adjudication. Here, the Second Circuit endorsed the very sort of hypothetical jurisdiction that Steel Company rejected. Although Steel Company dealt with subject matter jurisdiction, there's no material difference between an appellate court leapfrogging subject matter jurisdiction to decide merits issues in appellate court, and as here, leapfrogging personal jurisdiction to decide merits issues by reviving causes of actions that were previously dismissed. In both situations, the court is assuming power over a defendant with jurisdiction when jurisdiction remains in question. Perhaps Justice Thomas, then a circuit judge, put it best when he said, the truistic constraint on the federal judicial power then is this: a federal court may not decide cases when it cannot decide cases and must determine whether it can before it may. The majority here changes this fundamental precept to read in effect that under certain circumstances, a federal court should decide cases regardless of whether it can and need not determine whether it can before it does. So what this just said is you can still raise personal jurisdiction by way of subject matter jurisdiction. Why? Because they go hand in hand. So that's why you have to read things. That's why I said what I said. I could challenge personal jurisdiction at any time during the proceeding by way of personal jurisdiction and bring up they never had way of subject matter jurisdiction and bring up that they didn't have personal jurisdiction, and here's why. Mic drop. So read things thoroughly before you start questioning what I'm saying. So I politely tell you personal jurisdiction can be brought up anytime. You're out is subject matter jurisdiction to bring it up. I just read it. Okay. They are twins with each other. They work together. Okay. Because if I don't have personal jurisdiction, then there's nothing to talk about. We can't talk about the subject matter. All right. I really didn't want to go into that, but I did. The record is straight now. Yep. Like think about it. You could go in and all these traffic tickets that they ran on you without a trial. You could bring it up and show how you were not properly served. Or they ran through in the court without you having the right of trial by jury, all of that. All right, so let's go to the judicial notice. All right. I thought I had judicial notice up here. Let's see. I'll just do this. Let's see what judicial notice. Those of you been with me for a while know what it is, but we're gonna read it anyway. You know what? I'm gonna read it off of North Carolina, not from the federal code. I'm gonna read North Carolina's because every state has an identical rule to the federal rules. All right, so let's do this. All right, share the screen. Stop that. I wish there was a way to just flip between this. I gotta find another app that I could just go flip. So I put this. If you don't have this, here's a link in the chat for you to do this yourself. This is about judicial notice. And here's a link to that case that I just read. A lot of good information that you can use to for your case? All right. Taking a while to get into the chat. Yeah, it is. All right. So let's go to this one. Article 2, Judicial Notice. Rule 201, Judicial Notice of Adjudicative Facts. So what's an adjudicative fact? What is that? Let's look that up. Facts. Adjudicative facts of those that relate to the issue to be decided in the case, i.e., the who, what, where, when, and how, why of what happened. Legislative facts relate to matters of public policy. That's one. Let's get a better one. In adjudicative fact, a fact that is either legally operative or even so important as to be controlling on some question of law. Adjudicative facts of those which concern the parties, the sub-dispute, and are helpful in determining the proper outcome in a case. Okay? There you go. All right. Let's see what adjudicative facts are. All right. So let's read the law on that. This is North Carolina's statutes. Rule 201. A scope of rule. This rule governs only judicial notice of adjudicative facts. B, kind of facts. A judicially noticed fact must be one not subject to reasonable dispute, in that it is either one, generally known within the territorial jurisdiction of the trial court, or two, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So keep in mind what I just read. A judicially noticed fact must be one not subject to reasonable dispute, in that it is either one, generally known within the territorial jurisdiction of the trial court, or two, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. C, when discretionary, a court may take judicial notice whether requested or not. D, when mandatory, a court shall take judicial notice if requested by a party and supply with the necessary information. And E, opportunity to be heard. In a trial court, a party is entitled upon timely request to an opportunity to be heard as to the propriety of taking judicial notice and the tenure of the matter notice. In the absence of prior notification, the request may be made after judicial notice has been taken. So, let me read F. Time of taking note. Judicial notice may be taken at any stage of the proceeding. So you can do this at any stage. Very important. So why am I reading this today? Because simply, how many people have put in paperwork, put in motions, and the prosecutor, district attorneys just ignore you and they keep moving like you didn't even put it in? So here's your remedy. Put in the judicial notice of your filings. Take mandatory judicial notice of on June 15th, 2021, on or around June 15th, 2021, the alleged defendant entered into the record a motion to dismiss for lack of personal jurisdiction and subject matter jurisdiction. And at this time, I'm actually giving y'all the stuff to write right off my head. Y'all better be taking notes or go back and listen. At this time, I'm trying to use the right words. I'm better at just typing it out. And to date, the district attorney has not responded. It is now 30 days, 31 days past the time of filing. According to rule such and such, the district attorney has this many days to respond. Boom. Now you're setting up I'm just giving y'all general. Y'all could reword it. I'm just giving you an idea. They got to take judicial notice. Why? Because number one, it says a judicially noticed fact must be one not subject to reasonable dispute. If you put in as an exhibit a stamped copy of your filing, that can't be disputed. Generally known with the territorial jurisdiction of the trial court. That's in the territorial jurisdiction of the trial court. Capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So they can't question the clerk of court. Yes, you did file it. Now they're taking judicial notice of it. That's going to make the judge pay attention. What do I do now? And it's going to make it very hard for him to walk over you because taking judicial notice is a direct request from that judge to take that notice, take judicial notice. You putting the ball in his court now. I told you all of this is about court, hitting stuff back and forth, and you must do it in a proper way. And then go as far as pulling a motion for opportunity to be heard. Notice a motion of mandatory judicial notice and motion to be heard and an opportunity to be heard on mandatory judicial notice. Something like that. So a lot of y'all, a lot of you give kind of say, hey, they didn't answer my stuff. They didn't do this. They didn't do that. Here's your answer. This is how you do it. Now you putting the onus on them to respond. And you know what? I really honestly, especially in these traffic deals and all these little small issues, they're still not going to respond because they are so arrogant. I wouldn't even, you know what? Let me take that back. They may not be arrogant. They're just so overworked that they don't have time to respond like that. They're not, see, these traffic ticket courts, they're not used to anybody challenging them. They're just used to making deals. So who's going to, most law firms have what you call a paralegal that types up their paperwork for them. Who's typing up for a overworked DA? Who's doing this for them? Everything you do takes practice, right? And if you're not in the practice of responding and rebutting and getting all the stuff together, that's a lot of work for them. When they looking at 100 cases a day or more in traffic fines. I'm being understanding. They really don't have the time to do that, to have to pull a necessary response back to you. And when you do something like that, you're putting a monkey wrench in how that wheel works. That system works when you challenge that, but you have to challenge it properly, timely, properly, and effectively. Now you got them taking judicial notice. Now you get them to take judicial notice. Hey, let's just say, okay, this is how I would do it. You do what you want. I would do a motion to dismiss for the various, whatever reason I'm motion to dismiss. Most of my motion to dismiss are personal jurisdiction, subject matter jurisdiction. Then I'd wait the time for the time to expire. Then I'll do a motion for judgment on my motions. Right? And when I do that, that's when I'll do judicial notice. That's what I would do. After the time, I'll wait till after their time expired. Then I'll say, I need a judgment on these motion. See, you got to move the court. You got to ask them to give you a judgment on your pleadings. You got to put that in there or demand it, whatever way you want to put that. And in there, take judicial notice. Boom, boom, boom. And everything I filed will be in that judicial notice as an exhibit. Now, not only are you put it on the record once, you just put it on it twice. You put copies of your filings with the stamped copy as an exhibit. Boom. They got problems now. See, we have to get away from the days of just letting these people roll over us because they feel like they got the power to do that. They see when they roll over there, they know you have no army to help you. Well, not that they know. They think you don't have an army to help you, but you do. You have your ancestors. Number one, you have your mind, your spiritual power. You know, it always boggles my mind, when I see the same people having the same issues with every situation they run to. Someone is giving them resistance. Why? Because you believe in the resistance. You have a energy that is in alignment with resistance. If everything you do, they're stopping you. You're meeting resistance. I know that that's in your thoughts. I know. You see? MMBB says, wow, this is it. You are absolutely right. This is it. You got to put in everything that can help you. You see, you're going to have to cross your T's and dot your I's. They don't have to because they got the judge on their side. It's not supposed to be that way. And I'm not saying every judge is like that. But I also believe on the judge side, they so used to people just speeding, caught them speeding 91 and a 70. We're going to plead them down to 80 and a 70. $100 fine. And the person is sitting there, thank you, Your Honor. And they take that look, they take and pay the lesser fee and walk out of there because all they want to do is leave that courtroom. They don't mind giving up the money. But if you got 100 people at least paying $100, that court is banking. You see? Your job is to not let them bank on you. Because this is really about money. That's all it's about. It's not about stopping crime. When you look at the way the system is set up, it's really not about stopping true crimes. It's about money for the most part. They spend most of their resources setting up speed traps. Why? Because that's where the gravy is. It's just gravy. You see, speeding is, unless it's, ridiculously high speeds. Because in some countries, they don't even have I think Germany, the Autobahn, they don't even have a speed limit. You see, this is where the government doesn't trust people to do the right thing. So they make rules like this. And of course, that probably came from somebody just being reckless. And even with these rules, people still are reckless. It doesn't matter if you have the rules or not. Having the rules doesn't stop people from being reckless. All it does is oppress the people that are trying to be responsible. That's all it does. The people that are just trying to, go to work and live their life, it oppresses them. The system milks more money out of hardworking, honest people than it does the actual criminals. And I believe that's criminal. Because you ever sit in the traffic court, it's just regular folk in there. That's where they're getting all that money from. So there you have it. judicial notice. And they have to take mandatory judicial notice once you make that move. Let's see. I ain't even checked. If anybody on the line got their hand up, no, ain't everybody's in the link. Everybody's asking somebody want the link. You want the link for what? I didn't put it. You talking about the links to these PDFs? Okay. I'm looking at Blog Talk. I put the link in the YouTube. There it is. And the other one, I keep forgetting about Blog Talk. Treating Blog Talk like a stepchild. There it is. I put in the Elijah Faith. Still got the faithful Blog Talk listeners. And we got 44 people online and YouTube. It won't let me give you the YouTube. But when you're on Blog Talk, you get everything in real time. You know, on YouTube, it's a delay. There, that's YouTube. All right. So what's next? Questions. What y'all got? Y'all got something that y'all want to ask me on YouTube? I'll hang out with y'all a little bit longer. If y'all notice, I'm not wearing my headphones. I'm taking a break from these headphones. These headphones with these electromagnetic waves and these wireless Bluetooth, this and that. Eventually, you're gonna start having problems. If you're already hearing ringing in your ears and stuff like that, that's why. And along with a poor diet, it doesn't work. You know, so I just started at home turning off my Bluetooth, and moving my phone away from me at night. I might even consider just shutting it all the way down at night because, I mean, I don't talk to anybody late. I guess, you know, my daughter's at her mom's for the summer, and then, you know, Beth, that's the only reason why I would keep it on. But I don't talk to people late at night like that. But yeah, man, I had this ear here had some hearing issues. Now it's been restored for the most part, but they come from too many headphones. And I don't really wear a lot of headphones like that. You know, I think I had another headphone I was using for the show, and I think it was that headphone is not shielded properly. So yeah, I'm gonna do a class on the church bylaws, DJ B Thunder. I actually have the bylaws here. That's what I was waiting on to set those up. So I am gonna do that, do a class on how to do your bylaws. But and also probably in that class, I'm gonna show y'all how to set up y'all unincorporated nonprofit association. Which is basically a church. Same thing, because a church is a nonprofit. But some of y'all don't like the term church, and you can use temple, synagogue. I know you believe in something. I suggest that you strongly set up all of your entities under the jurisdiction of your faith. You see? Somebody put in there, common law statutes. Every court of this state shall take judicial notice of the common law statutes of every state, territory, and other jurisdiction of the United States. That's true. That is true. Yeah. I got 56 people, man. The listenership going up. I like that. Yes, it does. It has the E on it. See, if your CP 575, which is the form you get after you apply for your EIN for your church or whatever, if it don't have an E right after it, then it's not considered exempt. This is why you don't have to fill out paperwork for stuff like that. Actually, I got a video talking about that. Let me go to that video. I have to understand, people are telling y'all stuff, what to do, how to do it, without reading to you guys the rules of these things. And they're just telling y'all to do all kind of stuff. And a lot of y'all just run into it. Let's see. I did this a few months ago. Right now I'm looking on my channel. I-9 for nationals. Y'all need to look at that one. I-9 form for nationals. Notice of appearance. W-9s is for U.S. persons. Substitute W-8 bin and what you should know. Mandatory exceptions. There we go, baby. All right, I don't want it to play. You know, my thing be playing. Mandatory exception. You know what? I was like, where do I find a link so I could do this? And what's the title? 26 USC 6033 is the law. So let's die. All right, this is the video. Because I was having this challenge in the membership. I got people in the membership that listen to other people for information. You know, that's fine. You know, I don't care. You can listen to these people if you want to. You know, let me put it in Blog Talk too, for whoever's in Blog Talk. Somebody gave me something, a link. This will help. I can't copy and paste that. Let me see if I can copy and paste that. All right, thank you. Thank you with that. People be looking out. Oh, yeah, you know, I was looking for those. Oh, you talking about the all gone? All right. That sounds good. All right. I'm off topic, y'all. Hang on. Let me get to what I was doing. Thank you for that. I think that's Logic Face giving that me. Thank you. Go back to here. 26 USC 6033. Here it is. So let's read it. Let's read it. Let's share the screen too. Share. Stop screen. Share this. Chrome tab. 6033. I didn't have an opportunity to share it in the class on Sunday because I had to go. I had my daughter with me for the weekend. My granddaughter's birthday was, well, actually her birthday is like on the 20th or something, but they was having a little bit early and they had a party. We had a good time. Me, Beth, my daughter, my son, of course, and because that's his daughter, my granddaughter, and my grandson, and you know, all of the people he know, his family. Birthday party. It was at a place called Mad Splatter. It's a place where you put on a suit, you go in a room, and you just paint. You can paint on a canvas, but they let you paint on the wall. You get to throw it, you know, but you wear goggles and everything. It was actually fun. At first, I wasn't going to go, and then Beth kept talking to me about going, and I said, you know what? I'm going to go. You only live once, and it is my granddaughter's birthday, and she could see and experience that time with me. And went in there and I painted up something with their names on it, Ava and Kaden, and then I put they're both 6 years old and on it, and it was pretty cool. It really was. I enjoyed myself. You got to do stuff like that. You got to take time out with the family and just do something. Not think about work and not think about your problems, because those things are always going to be there. Enjoy when you're with family. Enjoy that time with family, and it was actually fun. You should try it out. I think they have them all over the place. They may not be called Mad Splatters, but according to Beth, they have them all over. You can do things like that. Just you don't have to be a special occasion. Just go there and just, hey, I want to paint. They had things you could buy, like little figurines. Plaster type material that you could paint up, and then they'll bake it. Like you could paint your own mug. I think I'm gonna do that. I'm gonna go to one of those. But okay, let's go to this. I'm kind of talking about birthday parties here. 26 USC Code 6033, returns by exempt organizations. Right. So this is 2633. See, what people are misunderstanding, you want to set it up as a 508. You want to set it not a 501, 50C3. Okay. Whatever. I'm 26 USC Code 6030, returns for exempt organizations. And I'm going to read this whole boring stuff to get to the point. Because the key to everything is to reading everything thoroughly. Okay? Except says 75816. I'm gonna get to that question because you said because I'm not a national. But let me just read this. Organizations required to file, except as provided in paragraph 3. Okay, it says except as provided in paragraph 3, which is right here, exceptions from filing, right here. Okay. Except every organization exempt from taxation under Section 501A shall file an annual return stating specifically the items of gross income, receipts, and disbursements, and such other information for the purpose of carrying out the internal revenue laws as the secretary may, by forms of regulations, prescribe, and shall keep such records. Render under oath such statements, make such other returns, and comply with such rules and regulations as the secretary may from time to time prescribe. Except that in the discretion of the secretary, any organization described in Section 401A may be relieved from stating in its return any information which is reported in returns filed by the employer which established such organization. 2, being a party to certain reportable transactions. Every tax exempt entity described in Section 4965C shall file in such form and manner and at such time as determined by the secretary a disclosure of A, such entities being a party to any prohibited tax shelter transaction as defined in Section 4965E, and the identity of any other party to such transaction which is known by such tax exempt entity. Exceptions from filing. Paragraph 1 shall not apply to churches, the integrated auxiliaries, and conventions or associations of churches. 2, any organization other than a private foundation as defined in Section 509A, described in subparagraph C, the gross receipts of which is in each taxable year are normally not more than $5,000, or the exclusively religious activities of any religious order. You see what I'm saying? So can you tell me in this code where it says anything about a 508? So if you're a church, temple, synagogue, because you go to the definitions, let's see if I can find definitions. Let's see. Information and returns. Inconsistent subject. Let's see. A lot of times it take a time to find these different. This is if you go read their rules, it says churches also mean temples, synagogues, and I think it's one other term. Okay. Y'all got it? So if you just simply go down there to the irs.gov, get your church EIN, and it's gonna have a I'm not even. I'll go into that later. I'll be more specific. I'll be more specific in the class. Let me shut up. But they know you're exempt once you check that box. There's no requirement for filing when you fill out that form. The 10, I think the 1023. You just made yourself. You put yourself under jurisdiction to be required to file. So you take all of your rights away and give them away. There you go. That's simple. All right. Let's go to these questions that's in the chat. Somebody said, even though I am not a national, I can still fight simple traffic tickets using it. Yes, you can. You are a national. You are always a national. You presume that you're not. Just because you didn't do your passport does not make you a national. Doing your passport just puts it on the record that you're a national. They know you're a national. Everything is presumed. They want you to presume that you're a U.S. citizen or a citizen of the United States so that you can check off that box. And now they got you because you signed that under penalty of perjury. Okay? All right, let's see. Let's go to some questions. Okay. Also, what do you do with the injunction once I have completed and printed out? Sorry if I'm off top. Injunctions, after you completed and printed out, you got to mail it out to the entities that you're supposed, mainly the sheriff. Even though I'm not an edible, I answered that. You could do infinite. You can get your passport before or after the name change. Doesn't matter. Infinite said, do you mind if I hit you up, little guys? I feel like I'll be all over the place. Sometimes I get really confused about what exactly I need to do. Yeah, get a consultation. AkeemL.com. AkeemL.com. Consultations are there if you want. I'll give you all the spiritual advice you need. Oh, he was talking to GJB Thunder. Okay. You fell for the 1023 trap. Yes, you did. But you can also, I think you can rescind that application. Me personally, I just go do it again. That's what I would do. I do it again. Let's see form 1023. Because if you're reading the instructions, I think the instructions tell y'all about that. Let's see here. Let's read the instructions. Instructions for 1023. All right, who can file this form? How to file? Okay. Meaning that filing assistance. I'm just reading the form to see the instructions. Whenever you fill in any of these forms, you need to read the instructions. Okay. All right. Let's look for. Let's see. Okay. I'll get to y'all questions in. Okay. Let's look at this one. Instructions. Right. Okay. I'm on a IRS website. Let's look at that. Let's look at this stuff. I mean, there's so much information here. And this is all free. Y'all don't need me to do this. But, I know sometimes you got too many things to do to follow up. So if you fill out this 1023 form, you should have just simply went to the IRS and typed up the instructions like I did. It says right here, how to request recognition of tax exempt status under 501c3. This is pertaining to the 1023 form right here. Instruction for form 1023. There, right? So Section 501c3 describes organizations organized and operate exclusive for religious, charitable, scientific testing for public safety, literary, or educational purposes, or to foster national, international, amateur sports competition, or for the prevention of cruelty to children and animals. Unless an exception applies, an organization must file Form 1023 or Form 1023 Easy if eligible. To obtain recognition of position from federal income tax under Section 501c3, you can find information about eligibility to file Form 1023 Easy, blah, blah, blah. Organizations not required to obtain recognition exemption. The following types of organizations may be considered tax exempt under 501c3 without filing Form 1023 or Form 1023 Easy. Churches. You don't have to file. You don't have to sign a contract. There it is. Even though these organizations aren't required to seek recognition exemption, they may choose to file. They may choose to receive a determination letter stating that they are recognized as exempt under Section 501c3 status. Determination letter will also state whether an organization must file annual information returns or notices. So these people file it because I want that letter. I want to show I got this. You see? Now let's keep reading. To qualify for an exemption, an organization must organize as a corporation, limited liability, an unincorporated association or a trust. Its organizing document, corporate articles of incorporation, blah, blah, blah. But y'all do know that a church is also can be an unincorporated association too. A church can also operate out of a trust. Okay, isn't the church a trust relationship between its members? Right? And if a church does incorporate, then it's unincorporated. It's a unincorporated religious association. So therefore, it qualifies right here. You see? Oh, there it is. Churches including synagogues, temples, and mosques. So I had the hardest time getting people to understand in the membership that, dude, it's this easy. Just go get your EIN, go get your bank account, and you can record it as an unincorporated association down at the county. Why do you want to do that? So you can keep the name so no one comes along and steals your name and use it where you are when you're doing your practicing your services. And that's all you need. Create your church bylaws, aka constitution. I would call it a constitution. You see? Yeah, I got the bylaws. I just show you the back of the book, not the front. I don't want nobody biting. We got eavesdroppers. Consultations are $75 for 30-minute Zoom. So you get to get on face to face and talk to me. All right. Oh, we got some hands up. Okay. I'm going to take these calls, but I got to keep it off. Do the headphones and turn it up. Okay. 504-714-5. Keep it short and sweet. Peace.
Greetings, Akeem. How you doing?
I'm doing good.
I had a question. Good. I had a question really quick regarding the I-9 form. So I am currently waiting for my name change appointment, my court date, and at the same time currently switching employers. So which they also participate in E-Verify. So I wanted to, of course, not include the social security number that's not in my proper name. And also filling out that form, the drop-down menu under country of issuance is not giving me the option that, I need to put, which is on my birth certificate. So
there's an option down there that says alien on there. What's going to happen when you do it that way? They're going to reject it online. And then you get to talk to a rep to explain what's going on.
Alien authorized to work, right? Or just...
Right. Alien authorized to work.
Okay.
Yes. So, and then you put your passport book number. And what's going to happen, I've done this personally, they're going to reject it. It's going to say they can't verify it. Then they give you instructions on who to talk to. You talk to that person and let them know that you're a national, American national, but not a citizen of the United States, or whatever you're calling yourself. Just let them know, and then they'll just, we got it, and move on, and they'll verify it. Okay, now, you might, on occasion get one person that might give you a little hard time, but stick to your guns. And what you need to say is this. That form is signed under penalty of perjury, and I'm not about to perjure myself because there are stiff penalties for that. That shuts it down. And then if it goes any further, of course, it's your religious beliefs. But, yeah, what's your next question?
Okay. Well, no, that was it. I just wanted to see if there was an affidavit not an affidavit.
You can't do it online. There's not an affidavit you can submit online when you do that. Not that I know of.
I meant to say explanatory statement just to explain why I don't want to include my social security number, or just wait until I can get my social that's in my proper name, and also explain why it's not
simple. Just say you don't use socials anymore because of religious objections to it.
Okay.
They can't question that. All right.
Okay.
All right. You could just draft up your own explanatory statement and put that on it. A couple of sentences. That's all they need to know. All right.
Okay. Thank you.
All right. You're welcome.
Peace.
All right. Let's go to the next one. 510-358.
Peace to the gods.
Peace to the God. What's going on?
What's happening, Akeem? Many blessings to you and your family, my man.
Thank you. Blessings to you too.
Thanks, bro. Okay, I'm gonna keep it short and sweet. All right. A matter of years back, I did the tax webinar, which was awesome. It kind of stopped the IRS for a while. Now, I got my tax burden's about $28,000, right?
Mm-hmm.
And of course, I got my national. I got everything in place. My declaration, all that stuff went in. It's all sealed. I got it.
How about your name change?
What do you say when you? No name change. Okay. No, I didn't change my name. That's only on my trust on my 9-8.
Okay. All right. So no name change. Go ahead. What's your question?
Basically, with that tax burden, I did the FOIL for my passport. Says on there, of course, sovereign. So I put those documents together, rebutted it, talking about what I did is I used 28 USC 1746-1 and put that in there, and basically just told them that about the signature was null and void because I did not have full disclosure of the contract that I was coerced into signing at the jobs I was working at that time. So now I came into the newfound knowledge and blah, 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 et cetera, signed the affidavit, sent it in. I sent it off about a week ago. But I'm just wondering, is that the correct measures, or shall I dip into something else to try to shut that down?
I shut it always
Or just-
down with a simple letter. If you did the IRS webinar, you have that letter, right?
It was one of years back.
Right.
When,
That's that letter still works like it did when I first created it. So I would submit
so
that,
I
and then
it.
I'll start using you're not an individual, you're not a taxpayer, and I'll just simply you questioning how much they're saying you owe. They're never gonna submit that. And then you can also take them into tax court to challenge it. And all they're gonna do is say they lack jurisdiction. So once they say that, there's no jurisdiction. That means that if they don't have jurisdiction, how do you keep coming after me for it? They never
can't move forward.
Yeah. So it's gonna take you some time to undo that because they don't like letting loose those claws. But yeah, you always challenge it. I don't know exactly which your letter you use. 26 USC. I always use the Constitution. And then I point out in their own rules that taxes is a gift on behalf of the treasury.
Exactly. I stated that. Then I stated the territories and basically
I don't get into all of that territory stuff. I just get into this. You say I owe you. Show me how I owe you. It's that simple. Give me a full accounting of what I owe, and they never going to answer that.
Right. I told them, but my opening statement was basically that, stating that, listen, I don't mind paying any kind of burdens that I owe in life. I'm honorable, child of God, the Most High. And then I went through and stated, if you can show me blah, 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 da, 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 on that affidavit. It's been a couple of weeks since I sent it in. So I'm just kind of waiting. Then I'm just going to send it.
You'll get a letter saying, hey, we got this letter from your third party. They always answer from a third party because when you're sending the letter, you sending it as yourself. And they realize that they got an illegist that they're trying to get the money from. So
right.
But yeah. Wait on the response to see how they respond. I already know how they're going to respond. They're going to tell you they need more time.
I'm sure that 30 to 45 day stuff.
Right.
Okay.
I seen where people did their name change and sent it into them, then their tax burden went away. I've seen that twice.
Name. God, I'm trying to keep the parent's name, but I did.
No, when I say name change, I mean just changing it so that it's recognized in its proper form, not in all caps.
Okay, upper and lower.
Right.
Okay.
I've seen people where they done that twice, and they got a letter saying you don't owe the money anymore. One guy got a letter saying came from like $60,000 down to $50.
Oh shit!
Just by the name change alone, nothing else. Yeah.
How do I go about that name? I never looked into that one.
Oh, I got the name change 1 and 2 webinar on my website.
All right, I'll take a look at that. And
all right.
Go from there.
Okay, peace.
All right, I'll keep you.
All right.
Peace.
Thank you, brother. All right, let's go to 904 386. 904 386.
All right. Hello. How you doing, Akeem? Peace of the God.
Peace of the God. What's going on? What's your question?
Right. A question about this motion for reconsideration on name change.
Question about motion for reconsideration on name change. What's your question?
All right. So I sent them that motion for reconsideration, and they still sent me back the same copy of the first letter, still not touching the subject matters of whatsoever.
Okay, so you're going to have to do an appeal then. Take it on up. Or just file in another county.
Okay, so file another county might...
Most people just file in another county.
Okay, I guess I'll go ahead and do that.
Yeah.
But just for future, I would like to learn a little bit about appeal. Could you say something about it, please and thank you?
All right, no problem. The best way to know about appeals is to go to your state's local court rules. They tell you exactly how to do appeal. That's how I I know how to do appeal. Actually, my son did an appeal on his own case by researching it himself. He actually got a video where a webinar about how to do an appeal. But you don't even have to, I mean, you could get that, but it's there. All of the information I put into webinars is right there, free resources. It just takes time for you to read and understand it. It tells you exactly. Simply put, a notice of appeal, you just say notice of appeal to judgment dated such and such and such. Just a couple of lines and boom, boom. Then you have 30 days to prepare your appeal. Like put your brief in to say why there's an error in that judgment. You can't put new evidence in. You can only refer to the evidence you already have in the case. That sums it up in a nutshell. Somebody said, don't you have to file a copy of injunction? You'll think it will be filed with the county clerk. Where? For what? That's old information, and you're listening to somebody else tell you that. The number to call in is 563-999-3615. Yeah. Yeah, you can file it with the county clerk, but it ain't going to do nothing but sit there and be filed. And you could ask everybody else who's done that. Somebody's asking about Miss Glenda's site. documentdays.com. Not wrong. Hang on. I'm going to give you the link. That's where she got authenticated documents. As soon as it pops up. I'll give y'all the link in just a minute. She went on and took my advice about setting up the church. She's got that set up. It's the first thing she got on the website. So let's go to the chat. There it is. There's a link to her site right there. Can you bring up jurisdiction? You could bring up jurisdiction and appeal if you mentioned it in your case. That's why you appeal, to challenge it. But I would do the void judgment first before I do an appeals if jurisdiction was a problem. I would say I would go to that court and have them try to avoid it, then move on to the appeals. Is a long process for some states, and it can be very complicated. So you really got to study what you need to do, because you got to get court transcripts, and some of them want you to put an appendix. Depends on the case, the court, the jurisdiction. Once again, read. Somebody, I gave them the number. I'm trying to wait for them to call in. If they're going to call in, give them a couple of more minutes. I'll answer the query. No, it's all right. I'm just letting you know that that information from a while back. Some of that stuff has been updated. Infinite is infinity. Is that the same infinity from before? I think it is. 563-999-3615. It's actually it's going across the screen. The number. It's right there on the screen, scrolling. Now I got my Cash App up. 563-999. There it is. 563-999-3615. Give me a couple of minutes to call in because I'm about to get off and take you to the house. 46 people on. And we had as much as 60 people on. That's good, man. I appreciate it. Make sure y'all put the likes on it. Not like and comment, like and subscribe, and hit the notification button. Like. The more you like, the more people can come to the channel to see what's going on. Because we just getting started here at Hindsight. Hotep Elohim Bo Bowmans. Just getting started. Miguel Bay, I gave you her site. You should have it. Man, I dropped heavy information on y'all tonight. You know, when I started the show, I didn't know what I wanted to talk about. I wasn't even I was talking about the spiritual thing. And usually I could get into the spiritual, but my spirit wasn't revved up, you know. But when I started talking about the law, I was revved up. Sometimes it's like that. I gave y'all some heavy information for y'all to use. I suggest y'all go back and listen to this show again and again. Share with your friends. Share with your family. You know, I guess he's not going to call in. You got 3 minutes. Curtis Williams says, massive appreciation. Thank you for that. Thank you. So back to what's coming. We're going to have a university, Hindsight University. They used to say that before. Hindsight, but it's going to be for real, where y'all just go in. I'm going to have all the material in one place where y'all can just sign up. Boom, boom, boom. Video after video. Just stream it just like you do Netflix. That's coming. That is coming. Make it easy. See, the membership is going to change. Right now, I do the classes such and such. But once I transition and get this going, I'm just put everybody that's already in the membership in that. And give them give them a bonus because they and show them appreciation of free time in there to enjoy the content. And then they have the option to, you know, stay for the new content. But that is coming. That's what I was doing all day today. Like on there, okay, how do I do this? How do I do that? So I can make it easier for y'all to get this information. And I know, you know what I'm doing for y'all? I'm trailblazing. I'm trailblazing for y'all. Actually, I don't have it on. It's not this one. But what's the give me a second. I think this is the one. Let's see. Give me a second. I'm waiting for this person to call in so that I can get that call, but they don't get on here soon. I'm getting off. Let's see. Oh, that is Shango. Sarah. Ogun. That's Solomon said that who I represent. Ogun. He is the first Oni of life after the demise of Oduduwa, a warrior and a powerful spirit of metalwork, well as rum and rum making. So you got to give him some rum. Trailblazer. So what I'm doing when I'm doing all of these upgrades, guess what happens to the other channels? They try to upgrade right behind me. And that's good. I like that. It keeps me moving forward. Every time they come behind me, I move forward. Because I already have my path laid out. Like I have it already, the blueprint is already laid out. And then I go, okay, I'm gonna do this now. And I'm gonna do this now. So the truth be told, they're never gonna catch up. I'm already, my mindset is already be eons away from them. Why? Because I like to study. I enjoy finding new information. But not only do I enjoy finding, I enjoy sharing it and upgrading and changing things. Because why? These people change all the time. So we got to change. We got to change when they change. We already got to be thinking ahead. This is like chess. You got to think several moves ahead. You see? It's not letting me call. I'll just catch you next time. All right, no problem, brother. I was trying to get you in there. So I think this was a hell of a show. This is one for the history books. So with that being said, roll out with the outro music. And peace, prosperity, and extreme wealth to all.